Good afternoon, everyone, and welcome. I'm really thrilled to have a fascinating discussion with Manisha Mithal, who is a partner at Wilson Sonsini and formerly spent a very long time at the FTC. And the topic of today's discussion is the FTC. In particular, what's going on at the FTC now? Where's the FTC going? How is the FTC addressing privacy issues and AI? What is the FTC going to be doing with AI, and how is it likely to be joining in the regulatory party with AI that is starting to happen? I'd love to also, at the outset, promote a little bit, if you'll permit me, my upcoming event, the Privacy and Security Forum. It's May 8th to the 10th of this year in Washington, D.C., held at GW University. And I'm really excited because we have some wonderful sessions on the FTC. Manisha is doing an FTC workshop, so an extensive deep dive into the FTC. So I definitely want to plug that. And we also have a really interesting session by Svetlana Gans, who is doing a session with attorney advisors who are currently at the FTC. And I've never seen a session quite like this. So there'll be quite a number of attorney advisors at the FTC in a discussion. So it'd be really interesting to hear from them. They play a very important role at the FTC. And so I think this is going to be a really innovative and interesting session that is planned for our event. So I'm really looking forward to all these wonderful things at the event. I should mention Svetlana is a partner at Gibson Dunn and also formerly at the FTC. So lots of FTC folks at our event and lots to discuss about the FTC now. So I'd like to begin by asking you, Manisha, what are some of the most distinctive and interesting developments recently that you're seeing coming out of the FTC with regard to privacy law?
Sure. Thanks, Dan. I think probably the most interesting thing is some of the remedies that are being included in the enforcement actions. So it used to be that the FTC would bring a case and they would say, okay, you lied about X, you can't lie about X anymore. They might include requirements to delete data. They might include requirements to have outside audits. But that was generally the typical order. And I would say over the last few years, even before Chair Khan came to the FTC, there started to be a shift. And there was a view that those remedies weren't deterrent enough. And so the FTC began looking for remedies that would cause companies to sit up and take notice a little bit more. And a couple of them stand out. One is algorithmic disgorgement. So the idea is that if you enrich your algorithm with illegally collected data, not only do you have to delete the data, but you have to delete any underlying algorithmic models that came up from that data. And you can see how that's a pretty big deterrent for companies that are using data to develop algorithms. So that's one remedy. Another remedy is individual liability. Again, when I was at the FTC starting out, it was thought that individual liability cases are more for people who are committing fraud, where it's a small company and the head of the company might just go off and start a new company in order to evade the order. And that was the purpose of individual liability. But now we're seeing that applied much more broadly in privacy and data security cases. And despite the decision a few years ago by the Supreme Court that the FTC couldn't get redress, I think another thing we're seeing at the FTC is that in privacy cases, they're looking for various theories to get money. So I think that's the biggest change. I think one thing that's noteworthy is that I think from a substantive perspective, what practices are unfair and what practices are deceptive, I actually don't think there's a lot of change over the last 3 years. I think the types of cases that are being brought now, whether it's BetterHelp or Rite Aid or some of the security cases that have recently been brought, I think the case selection and the cases that are being brought, I don't think they're that different from what's been brought before. So let me just open with that, and happy to drill down into any of that, Dan.
Oh yeah, I definitely would love to drill down on quite a lot of this because there's a lot of really interesting things that you've said. So let's start with algorithmic disgorgement or algorithmic destruction. And there's been some recent scholarship I've read about it, in particular, a really interesting piece by Tiffany Lee, who is, I think, somewhat skeptical of the remedy that, if you're trying to focus on a few individuals or some of the data, if you just delete, some of the data, you really essentially, the algorithm's already learned from it. So you can't do that. So then you have to get rid of the whole algorithm, which is what the FTC is doing in some cases. But then the question is, well, how much improperly gathered data warrants deleting the algorithm? What if it's just a fraction of the data the algorithm is trained on? Does that warrant deletion of the whole thing? And so what do you think about the exercise of this remedy? And are there ways to create some principles around it, or some guidance, or kind of where are we going with it? Or it's just really set out for the most extreme, egregious cases, and that's it? Or is this something that we would have companies expecting this all the time or some of the time?
Yeah, I'm sure the FTC is grappling with these very same questions. So, for example, if you look at the cases where they have used this remedy, it's either A, against very small companies that maybe didn't have the bargaining power or agreed to these settlements, or B, it looks like there may be cases, I would imagine, where the opposing party or the party that was being sued by the FTC may not have needed the algorithms. And so if you look at a case like Alexa, which the FTC brought last year, that also involved failure to delete data that consumers had requested. But I think to your point, Dan, I think the FTC would be very unpopular if they required Amazon to delete the algorithm that powers Alexa. And so in that case, algorithmic disgorgement was not a remedy. And so I think there's a number of factors that are in play. One, to your point, how big of the ocean are the illegally collected drops? If it's all of it, then I think that the FTC would look to disgorge the algorithm. How big is the company? How popular is the algorithm? What kind of consumer benefits come up from the algorithm? So I think the FTC is looking at all those factors, and I don't think we can predict. But I think the FTC is going to use it as a tool in its arsenal. So I think what happens is when the FTC finds that there's been an unfair or deceptive practice, they send a draft order to a company. And I can imagine those draft orders, including things like individual liability, algorithmic disgorgement, money, and companies may negotiate those out. So I think what we can say for sure is the FTC is going to be considering these remedies. And then it's up to companies to make arguments as to why they shouldn't be included in their cases.
So, I think that there's some, power limitations to the FTC. Like I tend to doubt no matter what, OpenAI, let's say they did something wrong in gathering the data. I tend to doubt the FTC is going to make them delete ChatGPT. I think that would be, pretty bold to delete, something with such a big company and an algorithm that is, so wildly popular. But, the other thing too is that these cases are almost all settlements, so they're all negotiated. And so in I think most of these cases, the companies are agreeing to delete the algorithm. It's something they've agreed to. And I'm wondering, based on your experience inside the FTC, I guess how malleable is this? So when you say the FTC requires as a remedy, it's essentially they're putting it in and they're fighting for it in a negotiation that ultimately companies are agreeing to. But I just wonder, how hard would they fight for it? Would they insist on it to go to court with it? How negotiable are things at the FTC? So once it starts putting it in, is that something that it's just a bargaining chip, and in a lot of cases it might have been there and then was taken out in negotiation. So I'm just curious, kind of from the insider's view, what's going on.
Yeah, so I think that the FTC has viewed this as kind of a potential stick, and as you put it, in some cases, maybe it's a bargaining chip. I think the FTC would really have to pick the right case. If a company didn't agree to it, then the FTC would have to try to go to court and get a court to award that remedy. And I think that would be an uphill battle for the FTC. So when the FTC goes to court, any relief it seeks has to be reasonably related to the conduct at issue. And so if a court perceives that, let's say, kind of a drop in the ocean of the algorithmic model was created using illegally obtained data, I think it'd be really hard for the FTC to argue that the court should disgorge the whole model. And so I think the FTC is going to have to think about that a little bit. So right now, I think a lot of companies don't want to litigate because they're concerned about reputational hit. They're concerned about resources and fighting the government. So I think, if there's the right case, companies said, this is a line of sand, and it's, by requiring me to disgorge my algorithm, you're going to put my entire business in jeopardy. And the company didn't agree to it, the FTC would have to go to court. I think the FTC would have to think long and hard about the facts of that particular case. Because once a court says, no, I'm not going to award you that remedy, it becomes harder for the FTC to get that in settlements in the future.
So you also mentioned the other remedy that we're seeing emerge, which is liability or responsibility, or things that attach to upper management. In particular, the Drizzly case, where the order follows the CEO, even if the CEO goes to another company. And I know that I think during the Facebook case, I believe, there were stories about, negotiations involving, potential, liability for Mark Zuckerberg that ultimately, didn't happen. But I'm wondering, is this going to be something of the future, that we're going to see this type of remedy more? Who would likely be held responsible? Could we see even potentially, the board? How would this likely develop? Do you see this happening more than just like a one-off case with Drizzly, or do you think this is the future?
I do think this is the future. And to answer your specific question about Drizzly, so in Drizzly, the CEO agreed to the settlement. And so I think you can imagine a case where a CEO doesn't agree to a settlement, and the FTC would have to fight in court about that, whether that individual was liable. And the FTC has had some success in non-fraud cases in getting courts to hold individuals liable. I think there's a couple of things. So I think there's a couple of ways the FTC could go here. I think number one, they're definitely looking at naming CEOs. I think part of that is a bargaining chip. Part of it is kind of a concern about the future, and and part of it is kind of trying to create deterrence in the industry. I think where I become a little bit more worried is when the FTC starts naming people like chief compliance officers or data security officers, or general counsels, or other kind of compliance related positions. And we've seen that happen, not in the privacy area so much as in the advertising area. I think there was a chief marketing officer that was named in one of the advertising cases. And I think my concern there is that, if these compliance officers get named, then companies are going to have more trouble in recruiting for that position. If there's a possibility you could be held individually liable and take that reputational hit, I think it would deter a lot of people from applying for those positions. So I think that's on one end. I think you can make the same argument for board liability. I don't think we've seen board members named in FTC cases yet, but certainly from the guidance we're seeing from the FTC, there's been guidance suggesting that boards should take more responsibility for privacy and cybersecurity. There's the GLB safeguards rule, which basically requires cybersecurity reporting to the board. And so typically what we see is FTC guidance first, and then perhaps cases. And so I wouldn't be surprised if we saw cases where the FTC tried to name individual board members for privacy and cybersecurity failings.
Yeah, I think that's just a very interesting issue generally is, who should be held responsible. And I think that, here in the United States, a lot of compliance officers and privacy officers don't have, full independence, so they can be terminated if they don't do what, the company wants them to do at the end of the day. And unlike in the EU, the DPO has legal protection against being terminated for, bringing some bad news or trying to push back. So it seems to me, problematic to hold these folks responsible when they ultimately don't have the final say. They can make a recommendation. But those where the buck stops with, like, the C-suite, CEO, board, they are responsible. They are the final decision maker. And so, unless they put that kind of independence or give that kind of independence to their compliance officials, I think then the buck stops with them, and, holding them responsible does move the needle. I think that, if you're at that level and have that kind of decision-making power, they're deciding what the company ultimately does, and whether the company is going to follow the law or not, how many resources are going to be put into the program. So, I mean, I'm generally in favor of that kind of liability at the very, very top. There should be some responsibility for this, because I think it really would move the needle a lot more. Punishing lower level officials who really don't have the ultimate power seems to me just to really put them in the crosshairs of something they can't fully control. I don't know what you think about that, but that's.
Yeah, I mean, I think there's a lot of different fact patterns, and I don't know that one size fits all. So you could have a fact pattern where a CEO or a board, gets a recommendation from the CISO and the GC, and they say, look, we think, we don't have the resources to do this, or we think we should prioritize X over Y. And you could imagine a situation where the kind of head of the company or the highest level defers to that level. And if they're deferring to that recommendation, I think it's difficult to say that they're fully culpable. Whereas you could have another fact pattern where they're like ignoring all warnings from the CISO and the general counsel. And then I think you have, a different calculus there. So I do think that it's a very kind of fact specific inquiry.
Yeah. And is the FTC able to get those facts? So can the FTC find out exactly, okay, what conversations did, the CPO or CISO have with the CEO, and what did the board learn? What was presented to the board? And, it would necessitate finding out all those internal happenings and conversations and documents that, would be circulating. And that's something the FTC would be gathering.
Yeah, I mean, I think there's a lot of debates over privilege, right? So, under what circumstances is an attorney in the room, does that render the communications privilege such that the FTC can't get those that information? I mean, I guess another point I just wanted to raise here is that I think there's a trade-off between the FTC going to the ends of the earth to get that evidence versus and spending investigative resources to do that, versus bringing more cases or holding more workshops or doing more rulemaking. So all of this is a trade-off, right? So if they're going to hold a CEO of a major company responsible, they're going to need to do a lot of fact finding and a lot of investigation, and that's going to take away from other investigations. So I don't think it's a black and white issue. I think there's just many factors that go into the calculus there, both inside the FTC and in terms of the impact it has on the public.
So I want to get to the rulemaking. You mentioned it briefly, and I think what you just said is a good segue into this, because there are some trade-offs with this, and the FTC has finally used the Magnuson-Moss rulemaking, which is a very cumbersome, clunky, difficult procedure. So for a long time, the FTC has kind of stayed away from rulemaking because of that procedure. But a few years ago has really launched into making a rule. And so they're making a rule as we speak. I'm curious what you think about the strategy of that, the implications of that. Why are they going down this road, and are they likely to succeed? And what do you think is going to become of all this?
Yeah, so just maybe to level set and provide some background here. So there are two kinds of rulemaking that the FTC has. One is APA, notice and comment rulemaking, and that's very straightforward. They put out a proposed rule, you get comment, and then you do a final rule. But they have to have Congress's blessing to do an APA rulemaking. So they recently did a notice for a proposed rulemaking for COPPA. That is an example of an APA rulemaking where Congress gave it the authority under the Children's Online Privacy Protection Act to do this APA rulemaking authority. The FTC could get comments and it could issue a final rule. But there's this other kind of rulemaking authority called Magnuson-Moss rulemaking authority, which is a kind of special form of rulemaking that was imposed on the FTC when Congress thought the FTC was overreaching with its rulemaking agenda. And so Magnuson-Moss rulemaking requires an advance notice of proposed rulemaking, congressional notice, then a notice of proposed rulemaking, then hearings presided over by a hearing officer, the opportunity of the public to designate or to suggest material issues of disputed fact. There to be a report from the commission. And so typically, historically, this rulemaking has been on the books since the 1970s. The FTC had not been using it, and the average rulemaking under Magnuson-Moss took about 5 to 7 years. And that didn't count rulemakings that got stuck during changes in administration and just were not pursued when a new administration came in. And so the conventional wisdom at the FTC was, well, rather than spending 5 to 7 years in rulemaking, we should just spend resources to bring more enforcement actions. And a couple of years ago, that thinking changed. And the criticism was, well, the FTC keeps saying we're using all the tools in our toolbox, but we're really not using all the tools in our toolbox because we've never tried to use Magnuson-Moss rulemaking authority. And so back in, I think, 2021 it was, the FTC actually removed some of the limitations on commissional rulemaking. So most of the limitations are done by Congress, but there were some that were rule-based, and the FTC rolled those back in preparation for an ambitious rulemaking agenda, including a privacy rulemaking. So on the privacy front, in August 2022, the FTC issued an advance notice of proposed rulemaking and sought comments. They got public comments, and we're now in March 2024, and we haven't yet seen a notice of proposed rulemaking. And I think that just goes to the point about how long these rulemakings take. Even if the FTC were to issue a notice of proposed rulemaking today, I don't know that it could be completed before the end of the administration. And so I think that's the trade-off. They've spent a lot of resources on this rulemaking. If that's not going to happen, if it's ultimately not going to become final, then maybe that's time that could have been better spent on cases. So I think that's the debate. Should you spend more time on cases, or should you try for the rulemaking, even if it's not ultimately successful?
Yeah, I've somewhat been a little skeptical of the rulemaking and whether it's going to really get us more than it costs, because the FTC has, through its enforcement, very strategically used its enforcement to essentially lay down what I consider to be a kind of quasi-common law of privacy. And if you look at all the cases and what the cases are doing, and the FTC has been, I think, fairly consistent about what it's doing, you see, standards and rules develop through those cases, just like the common law. We start to see things fleshed out over the years, and we've had more than 20 years of FTC jurisprudence in this area. So we have a lot, and the FTC can, it's a very broad interpretation of Section 5 of the FTC Act, which is very broad, just as unfair and deceptive, but very little else. So you can really mold that and do quite a lot with it. It's a very different style than the traditional statutory or rule-based rules that are very detailed and very long. But it's still there. And something, well, it's not like etched in stone, it's not written in code, but it's still there and it still works. It's just maybe underappreciated by the EU or a lot of the world. But it's there. And I wonder if the FTC were to create a rule, does that fossilize in what's in the rule? So then the FTC goes and says, oh, we want to do something new. We want to do something innovative. Now we want to do a new remedy like, algorithmic disgorgement. But it's not in the rule. It's not mentioned in the rule. And then they start doing it. And then people are going to say, well, you came up with the rule. Now you're doing all this stuff outside the rule. So that seemingly is beyond. And the FTC said, no, we didn't want to limit ourselves with the rule. But it's sort of then, then people would say, well, it's kind of confusing, right? You came up with this rule, but now you're doing all sorts of stuff that aren't in the rule. So then does this mean that there's pressure on the FTC to stick to the four corners of the rule rather than have the freedom to evolve the law through the enforcement? And so I'm wondering, if the rule, could be a blessing, but also could be a curse.
Yeah. I think these are probably debates that are happening throughout the FTC right now. So I think the main point and the main reason the FTC wants to do this is because so that it can get civil penalties for first-time violations. So back in a couple of years ago, the Supreme Court said that the FTC couldn't get monetary redress under Section 5 of the FTC Act. And the FTC continues to be concerned about underdeterrence of the FTC Act. And one of the ways in which it's trying to overcome that decision is by doing a bunch of rulemakings that would give the FTC civil penalty authority. And then I think the other thing that's happening is if you look at the advance notice of proposed rulemaking on the privacy rulemaking, it is very broad. The FTC asks 95 questions. And to your point, Dan, I think what they're trying to do is say, okay, let's cover the waterfront here and make sure we're covering the waterfront so that we can get civil penalties for everything. Now, I think that's a little bit misguided. I'm of the view that if the FTC wants to do a successful rulemaking, it probably shouldn't try to do everything. It should probably try to cut off portions that are realistic to get done. But I'm sure that debate is raging within the building, is that like, what would we cut off? There may be some low-hanging fruit that would be easier to get through, but then what's going to happen if we don't get civil penalties for this other kind of conduct? And I'm not particularly worried about the issue you flag, Dan, because there are areas where the FTC has rulemaking, COPPA, for example, and that is applicable to a specific type of website or online service. But I do think that there could be a Magnuson-Moss rule, and then the FTC would still have the authority beyond Magnuson-Moss to allege a Section 5 violation. But I think, there are companies out there who would argue, no, you covered the waterfront. Now you can't develop these new practices through Section 5 because you had the rule. So I do think there's a lot of factors at play here. And I do think that some companies would make the argument that you're making, Dan, if the rule is issued and there's something new that comes down the pike, that it's somehow preempted because they issued the rule.
So another strategy the FTC could do is that in light of the near impossibility to pass a comprehensive privacy law, it seems like there's a big, impasse, and Congress can't change a light bulb or, barely can pass a budget or do anything. You can't even tie their shoes. So it's very unlikely that, we're going to see the federal law. But what if, the FTC could kind of do like what happened with HIPAA, right? You could have FTC HIPAA. And sort of the new, a comprehensive federal privacy rule through the FTC that would essentially look like, a U.S. version of GDPR, perhaps. So it's conceivable the FTC could do something like that, knowing that Congress has kind of tried so many times and failed for the federal law. So especially with the last iteration, it kind of looks like, the lane is open at this point for that. Is that a possibility, or do you think that's kind of unlikely?
I think it's highly unlikely. I think we are in March of 2024. I think that we'll have the election. We don't know what's going to happen in January 2025. But the fact that we haven't seen a proposal yet and that it's taken, I think it's been a priority for this administration at the FTC to have this rule, but we didn't see an advance notice of proposed rulemaking until August 2022. We still haven't seen a notice of proposed rulemaking. So I just don't think it's very likely. But I think to your point, Dan, if it does happen, then Congress certainly doesn't have an incentive to pass comprehensive federal privacy legislation. They might just say, oh, the FTC is taking care of it.
Yeah, and I think that's very well, that's what Congress did with HIPAA. I mean, Congress had reserved itself the right to pass such a thing and mention that they might do it. And then, but if they don't, then, it would be HHS that created the rule. That's how HIPAA comes to be many years after the passage of the HIPAA law. And I just wonder, let's assume, hope, the Biden administration wins again. We'll have 4 more years of time to make this rule. I mean, who knows what happens if that doesn't happen? But let's say it does. Then there's the path, perhaps. But I don't think that the Congress is going to say to the FTC, "Wait up, we're going to really do it." I think at this point, I'd be surprised if Congress is going to seriously try to pass a comprehensive law anytime soon, because I think they hit the brick wall with California and the preemption issue, which is, I think, the big brick wall that's the impasse. But you have a situation where I think industry wants something like this much more than they did 20 years ago. But we'll see how it all plays out. But I think obviously, the election will be a big factor in, whether or not we'll see what we'll see out of the FTC on privacy.
Yeah. And let me just make a couple of points on what you just said. So I think, first of all, I think you saw the commissioners essentially inviting Congress. When they put out the advance notice of proposed rulemaking on privacy, they said, look, if Congress passes a law, we'll stand down. And that was in August 2022. And obviously that's not happening. I think the other point I want to make is that even with another 4 years, I mean, you said that industry wants this. I think industry wants a comprehensive federal privacy law passed by Congress, but I don't think they want, a regulation issued by the FTC. And so, or a lot of them don't, and it'll remain to be seen how the rule looks. But again, like going through the steps of the MAGMOS process that I talked about, they have to issue the notice of proposed rulemaking. They have to entertain suggestions of material issues of disputed fact that would be addressed in a hearing. So we've seen this with junk fees and negative option, where commenters are raising these disputed issues of material fact. There have to be multiple hearings. Then there has to be a report. Then even after a final rule, the standard for judicial review is pretty low. It's not arbitrary and capricious. It's, was there substantial evidence in the record to support the FTC's rule? And so I think you're going to see a lot of appeals by companies to a final rule. So that's how I see it play out.
Yeah. I mean, I think generally, I think the FTC has generally been a friend industry. I mean, it's the U.S. self-regulatory approach was essentially, backstopped by the FTC enforcement of privacy policies. Who knows what would have happened if the FTC had not been there? I think companies think, oh, well, it's just a void. But, just like chess, every move, there's another move in response that a lot of times I think industry doesn't think about. Couple things on the fines, because this is sort of the prize that I think everyone says, fines talk. If the FTC could fine, that's going to be great. And a couple things on the fines. One is, what happens to the money? Like when the money does it just go into the kind of bottomless pit of the U.S. Treasury, or does the FTC get to use it? Can anything be given back to consumers from this money? And then generally, the other question is, are fines really effective at the end of the day? Because we've seen some fines, the 20 million fine to Google, which is what they make in less than a second. or the $5 billion fine to Facebook, which sounds like a lot, but at the end of the day, Facebook stock goes up on the day of the fine or something like that. So wonder are fines really what is driving this? How good are the fines, and kind of what uses can be put to that money?
Yeah, so I think there's kind of like a little bit of a double speak on fines. So just to answer your initial question, the fines go to the U.S. Treasury. There are certain circumstances, for example, with a rule violation, that the FTC can get damages directly to consumers, but the FTC doesn't take the money for itself. And I think a lot of times for companies, they prefer redress to consumers as opposed to fines to the Treasury, because there's some tax advantage to having redress. But I think when I talk about doublespeak, I think on the one hand, there was the concern following the AMG case that the FTC didn't have the authority to get consumer redress. And so there was this doubling down on, let's do Magnuson-Moss rules so we can get fines. Let's allege rule violations so that we can get fines, and let's use our kind of fining authority as another stick. But then we see, on the other hand, that, fines aren't enough, like exactly the examples you mentioned, Dan. And that's why we need non-monetary deterrents like individual liability and algorithmic disgorgement. I think the truth is that these are all tools in the FTC's arsenal. I think some tools are better suited to some things than others. You can imagine a smaller company where a large fine would really, really hurt their business. You can imagine another company where there's no fine, but the injunctive relief essentially would put them out of business. And so I think it's just kind of a menu of options that the FTC has, kind of tools in their arsenal. And I think they're going to continue to assert those on a case-by-case basis. And Dan, before we leave this topic, I see some comments in the chat. One person said that data privacy is so politically tied now more than ever. And I would say that, like, I would kind of push back on that idea. I actually think data privacy is a pretty bipartisan issue. And so I think with the ADPPA, the version of federal privacy legislation we saw, there was a remarkable consensus among Republicans and Democrats. And I think, Dan, you're exactly right. It's the preemption issues that held that back. And so I think that while there is substantive consensus, and you see a lot of the cases that come out of the FTC, even when Republicans were there, were 5-0, 4-0. It'll be interesting to see now that the new commissioners have been approved. They'll be back to a 5-0 commission. So it'll be interesting to see whether the case selection or remedies or things like that are different.
So looking a little bit to the future of kind of like where the FTC might go and what might happen, one thing that is kind of on the horizon is the U.S. Supreme Court is now reconsidering the Chevron doctrine. The Chevron doctrine is essentially deference that is given to agencies in interpreting their laws. So I would presume it would apply to the FTC's interpretations of the FTC Act. And that if Chevron is overruled, which seems like a very likely possibility, then what happens to the FTC? What are some of the implications that could happen if the court were to overturn Chevron?
Yeah, I mean, I don't think that there's a huge implication for the FTC. I think the majority of the FTC's work is settlements, as you point out. Now, companies might say, aha, now they don't have Chevron deference, maybe we should litigate. But I think the incentives for settlement are still there for a lot of companies, the reputational, the resource constraints, et cetera. And when the FTC has gone to court, so in the Wyndham case, for example, I think the FTC did not get Chevron deference in that case. And the FTC prevailed on that. So, I mean, if you look at, Section 5 of the FTC Act, it is quite broad, unfair, deceptive practices. And so I can't imagine there's not going to be any deference to kind of the lower courts or whatever courts decide on that. So, and to the FTC, frankly. So I guess I think there are other things that are larger game changers, things like, the Axon, the kind of the ALJ constitutionality. I think there's the AMG decision was a big one, kind of how what's going to happen in the Facebook case. I think those are kind of bigger existential issues for the FTC.
Well, I guess what I had in mind was in particular the FTC's interpretation of unfairness, and less so than deception, because unfairness has a bunch of things in it, especially the idea of substantial harm, and that the FTC has interpreted in a very different way than how courts have interpreted harm, because I've written a lot on harm, and I think courts have really been narrow, and I think a lot of times somewhat antiquated in how they understand harm. They really struggle. And we see with the Supreme Court standing cases, some what I think are kind of ridiculous decisions, such that like labeling someone a terrorist in your credit reports is somehow not a harm. So I wonder if that would be the area that we would see curtailed. That would be the push, would be, courts now would be able to say, we're going to impose our view of harm on the unfairness, and essentially would, I think, limit a lot of the FTC's unfairness authority in that regard. I think a lot of the privacy cases with unfairness have a pretty loose conception of harm, societal harm, which generally is not recognized by courts, or emotional distress or harm, future harm, which courts or more speculative harm, et cetera. Courts could be pretty, difficult on that.
Yeah, I think we've seen this play out in the Kochava case. So Kochava is a location data broker that did not settle with the FTC. The FTC alleged that its sale and use of location data was unfair. And Kochava filed a motion to dismiss, and they said the FTC has not met its burden of showing substantial injury, or likely, cause the conduct caused or was likely to cause substantial injury. If anything, the FTC's complaint was completely speculative. And I actually think that the court, even though the FTC lost the first time, I think the court vindicated the FTC's authority to a large extent by saying, hey, this is, it doesn't have to be financial harm. It doesn't have to be physical harm. This is the kind of cognizable harm under the unfairness statement. So you have precedent. So the FTC has a court precedent for that. And then they said, look, in the original complaint, your allegations of harm were speculative, and we'll consider if you have more kind of concrete examples of harm. So the FTC filed an amended complaint, and that survived the motion to dismiss. So I guess my point here is that with the Wyndham case, with Kochava, there's already some jurisprudence built up on this. And I think, Chevron deference. I think Chevron deference comes more into play when an agency is interpreting its own rules, whereas this is a congressional statute. And so I think that makes it a little bit different. But I take your point, Dan, that, courts are hostile to the administrative state right now, and they're kind of so I think the FTC will face pushback from courts if it goes further.
Yeah, a lot of it depends on where you are. I think if you're in the Fifth Circuit, who knows how Wyndham would have come out, or anything would come out really on the Fifth.
But Idaho, so yeah. So
I'd like to get to AI, and AI is the rage these days. Everyone's talking about AI. You have to put AI into everything, and practically AI is everything at this point. Anything with code now is AI. But in particular, I'm curious about what you think the FTC might do in this area, because we have the EU has, of course, jumped out first with the AI Act, and so will Congress pass its own AI Act? We know what the odds are of that. But the FTC has the FTC Act and has tools in its quiver that, there's no reason why they wouldn't potentially apply to AI. And so I'm wondering what your thoughts are on how the FTC is going to move in this area.
Yeah, so we've seen a lot of guidance come out of the FTC on AI. So we saw originally a statement about we now call it the practice of AI washing, which is kind of like a play on kind of greenwashing or some of the other claims where a company exaggerates what its AI can do. And so the FTC has said, make sure that you can substantiate whatever statements you have about AI. And so I think that's one area where I think we're going to see the FTC focus, and we already have seen the FTC focus. There was a case that they brought against a company that was telling small businesses that we can kind of optimize your Amazon storefront, and we can help you with your kind of e-commerce targeting, and we use AI to do that. Well, they really didn't use AI, so the FTC alleged that that was deceptive. So I think that's one area we're going to see the FTC be active. And the second area that the FTC has put out a lot of statements on is the idea that companies need to consider the risks of their AI product, do a risk assessment, and reasonably address those risks. So to the extent that there are safety risks with the AI, to the extent there are privacy risks with the AI, companies have to take reasonable steps to address and mitigate those risks. And I think we're, where we see policy statements and guidance, we often see cases follow. So we saw that with biometrics. The FTC issued a biometric policy statement and then put out the Rite Aid case. We saw it in health, where the FTC put out health statements, and then we saw a number of health cases from the FTC. So I can imagine we're going to see some things here. I think one of the more controversial things that the FTC has done is they did this impersonation rulemaking. And then they added a supplemental notice of proposed rulemaking saying, AI companies, if your products will allow companies to impersonate government or businesses, then you have to take, or if you knew or should have known that your AI tool could be used, for example, for deep fakes, then you could be held liable, and we have rulemaking authority, and we'll get civil penalties against you. So that is open for public comment right now, and so the FTC can comment on that. So that just shows the types of things that the FTC is thinking. And we see a comment here, even the SEC is targeting AI washing. That's exactly right. I see another comment that asks about AI, is it ultimately just risk-based? I think the answer is yes, it's risk-based, but I think if we see a big article about some security breach on AI or some sort of instance where consumers' data was compromised, I think it's likely the FTC will ask questions about that incident. And if a company doesn't have risk-based processes and procedures in place, I think the FTC would likely want to bring an action against that company.
Yeah, I think it's really interesting because, the FTC Act's breadth and to some extent, vagueness is a plus here because, there's a ton of deception that can be wrapped up with AI, the AI washing. And then a lot of it could be deemed unfair, such as, unreasonable risk or improper data collection, of which the algorithmic disgorgement is obviously very relevant to AI, since these algorithms are built based on massive scrapes of the internet, which I think is a dubious practice. I'm writing about this with Professor Woodrow Hartzog because I think it's really interesting. It's kind of gone on, and it's unclear how it squares with a lot of privacy law. And then we've got just unfairness that could be for any potential use of AI, or creating AI without certain protections or safeguards from bad uses. So I think one thing that's really interesting with AI that's very complicated is it's not like your traditional thing where you have company gathers data from somebody and then uses it. AI, it's there's the AI creator, but then the AI algorithm is often shared and then used and tinkered with and developed by many, and then used by many others. And the problems can occur in any one of these stages, from the original creator to the subsequent folks that take it and adapt it to the end user who's putting in prompts and trying to generate things, all of whom are ultimately a part of the final output, of the final product. So I'm wondering how we sort that out. Because who does the FTC go after? Is it just the creator of the algorithm? Is it just like the open AIs, or what about the users of it?
Yeah, and I do think the FTC has some experience in this area where there's multiple parties. So, like, think about a data breach at a service provider. Is the service provider responsible? Is the customer responsible? Who has to give the notice? We see it with telemarketing. You have the actual product being advertised. You have the boiler room. You have the kind of people who are writing the scripts. You have the companies that are providing visuals. And so it's all part of in the case of telemarketing, common enterprise here. And the FTC has managed to they have this assisting and facilitating authority in the telemarketing sales rule. But so I do think that the FTC will look at who is the most directly responsible party for the harm at issue. And actually, another area where the FTC has been looking at this is COPPA, right? So you have like the website that's consumer facing. You might have an ad network that is doing behaviorally targeted ads to kids. You might have an ad exchange and multiple parties down the line. You might have a data broker that they're getting data from. And so I think you see these kind of complex scenarios in privacy and security and now AI. And I think what the FTC usually does is they say, the person directly responsible has direct liability, and other people in the chain are not strictly liable, but unless they, I think there's a couple of theories. They like put in the stream of commerce the means and instrumentalities of creating that harm, or if they knew or should have reason to know that this harm was being caused and they didn't do anything about it. So I think the FTC has multiple theories when there's a number of players involved.
So we're getting close to the end of the hour, and I'd like to ask a question about the practice on the other side of things. Now you're on the other side, and I'm curious how things kind of look on the other side, and then also you don't have to give all your secrets away, but what are some of the things about the FTC that you learned from being there that you think are things that people don't know that well, or misconceptions or myths, or things that you find that from being inside that could help those outside have better insight about how the FTC thinks and acts?
Yeah, maybe I'll take that question first. One of the things that's been interesting on this side is people are like, do you know the chair? Do you know the commissioners? And I think what they forget is that most of the work is really done by the staff, and the recommendations are made by the staff, and there's a lot of deference to staff. And so I wish people knew, the really, really important role played by staff attorneys, and it is to companies' interests to engage with the line level staff that reach out to them, as opposed to kind of saying, "Oh, this is a waste of my time. I'm going to wait till I get to the commissioners." So I think that's one thing. I think the other thing is that there's a lot of press around Chair Khan and the changes she's made, and how kind of this is like a new day and new issues. But I think people are surprised when I talk about the remarkable amount of continuity that there has been at the agency, as I mentioned, even when Commissioner Phillips and Commissioner Wilson were there were a lot of 5-0 votes on privacy. Commissioner Wilson was actually a big champion of privacy, even though she was a Republican. And there's just a lot of continuity. And a lot of the cases that have been announced by Chair Khan, were started in a Republican administration. So I think that there's I think the press tends to focus on differences and divisions and kind of new things, but I think there's a lot of continuity as well. In terms of what I might have done differently had I known kind of what I know now, not that much. I mean, I think I might have been nicer about deadlines. When I was at the agency, I'd be like, oh, well, you have an army, you private law firms have an army of people you could put on something. Of course you can meet this deadline. I might have been more sympathetic now that I'm on this side. But I think on substance, I think, I think the process it allows for companies to come in and make their case, to provide the arguments, the legal, the factual, and the policy arguments, to try to get the FTC and staff to see it a different way. And I think strong advocacy has an effect. So that's something that I would just say I've seen on both sides of the aisle.
Great. Well, I think that, this kind of wraps up our conversation. Really, there's a lot more to talk about, but I think everything is going to involve, quite a lot. So we should probably wrap it up. And I would love to have a further conversations with you about the FTC. I think it's endlessly fascinating and quite important, because the FTC really is our de facto data protection authority, until we have something else, and federal law, which we probably, who knows if we'll ever have. I mean, the FTC is it, for, the largest jurisdiction and the most activity and privacy that we have here in the United States. So it's very important. And I think that, we see it has a lot of tools at its disposal and is still very active. And will be active for years to come. So it's really interesting to get your thoughts on, what the FTC is doing. And I think you're right that, follow the FTC's guidance and the stuff they're putting out, because they are telegraphing. They're not, they don't typically don't do surprises. They kind of tell you what they're going to do. Just pay attention to that stuff, because that's the preview. So anyway, thank you so much for joining us. This was awesome. I really appreciate your time here today.
Thanks, Dan.